Hello, my name is Selbika Kajanova and my student number is 1331340, and today I will give the presentation on what kind of reforms can be made in land law. It is to be submitted that the law of implied easement is flawed for several reasons. First, this presentation shall examine two specific examples of implied easements which have subsequently been argued to be inadequate. The two areas in question are car parking rights and easements of light. The problem underlying these areas and in implied easements as a whole can be understood either as a problem of too many overlapping tests or as a problem of implying mutual intention for an easement where in fact no such intention exists. The first issue is the place of car parking within implied easements. It has not been explained by the court in what circumstances or even whether a car parking right is capable of being an easement. The Court of Appeal had the opportunity to address these issues when it was examining a case relating to car parking rights. The Court of Appeal was examining the question of whether a car parking right could be acquired by prescription. The car in question had been parked in an area that was marked by a sign as a private car park. The Court of Appeal said on these facts there had been no acquirement of an easement by prescription. But despite the opportunity, the Court of Appeal did not discuss the wider questions of if and when a car parking right qualifies as an easement. It is submitted this is an example of limitations currently inherent in the law of easements, particularly implied easements. This case was about whether a right had been acquired not by express agreement, but by a course of action that implied a right. It was therefore open to the court to provide an answer to the questions of when and if car parking right is capable of establishing an easement. However, the court neglected to do so, and therefore it is submitted the court has left a lacuna in the case law relating to easements. It is further submitted that this lacuna is a pressing concern, given that the situation it applies to car parking rights may arise for many motorists. Therefore, the court had an opportunity to address a matter of significant consequence for many people, but it did not do so, and thus this area of implied easements is left uncertain. As mentioned, another area in which easements are relevant is easements of light. The problem identified with easements of light is that they arise from the perceived excesses of easements. First, implied easements can arise even without any consensual transaction, and thus can be a trap for the unwary. With easements of light, dominant owner is able to attain a right to light by prescription without needing to do anything except enjoy the light. The servient owner does not need to be aware that the dominant owner is in fact enjoying the light. There are several features of easements of light that make them special advantages for dominant owners and particularly disadvantages for servient owners. First, not only can they be acquired by prescription and thus without any bargain, they pertain to a right which is ironically not as visible as example. For example, a dominant owner using the servient owner's land as a right of way. Second, easements of light have a significant prohibitive impact on the servient land, not least of which includes its impact on any planning processes for the servient land. Third, because easements of light have a bearing on any developments proposed for the servient land, They can be very effective at hampering and frustrating development efforts and the servant land directly. Instead of merely requiring the servant owner to pay damages for infringing on the right to light, the dominant owner can seek an injunction that either prevents construction or demolishes it. The result is an adverse economic effect more widely felt throughout society. Dominant owners have become aware of their ability to claim an easement of a right to light and have accordingly sought to use the right as leverage when negotiating an agreement with a servant owner, such as requiring the servant owners to pay a price for the surrender on the dominant owner's part of the easement. It has been said that this outcome is undesirable because it inhibits effective development of the servant land through the imposition of further cost and delay on the part of the dominant owner. Indeed, the dominant owner can frustrate such development efforts where there is an easement of the right to light, even if the dominant owner in fact was not expecting or intending to enjoy the benefit of the easement. Further, what is implicated in these instances is a degree of uncertainty on the part of both the dominant owner and the servant owner. There is some disagreement about whether there is sufficient clarity regarding the circumstances in which an injunction supported by an easement of light will be granted. In any event, it is submitted that the main fact that there is disagreement about the criteria of injunction for easement of light is in itself evidence of uncertainty. It is further submitted that such uncertainty would entail costs and risks for both dominant and servant owners, where easement of light are concerned. Therefore, easements of light are currently in an unsatisfactory state, and thus a new statutory test has been recommended to aid clarity. In addition to specific examples discussed above, implied easements have attained reputation for being unnecessarily complex and complicated, with different tests applying for each form of implied easement, such that the law of easements requires specialist knowledge, and even the specialist can have difficulty in discerning whether or not an alleged easement is valid. The different forms of implied easement each have their own test, and these tests are not clearly demarcated, resulting in confusion. Some have argued that actually the law of implied easement can be understood by a single test, the test of intention. But it is submitted this is incorrect. As we have seen with easements of light, intention is too readily construed on the part of the parties for such an easily acquired and significant easement, particularly on the part of the servant owner. There is therefore a basis for arguing that the law of implied easement does not adhere to its supposed core principle of intention, because it is submitted intention cannot be construed by the court if such intention was not evident on the facts. In the summary, all of this foregoing discussion therefore leads to the question of how implied easements may be reformed, and there have been calls for the reform to take place via statute. But if the means of reform is via statute, the question is whether the legislature have an effective record of legislating easements. The key example is Section 62 of the Law of Property Act 1925, which is said to expressly include a word-saving device for expediting conveyancing. It is said to be generally accepted that the purpose of the words in that section is to ensure that the land can be used and enjoyed in the same manner by the person acquiring the land as it was used and enjoyed by the person disposing of the land. But the section has encountered a criticism relating to its application. Specifically, there has been criticism of the so-called uplift effect of the general words implicated by the section into conveyancing agreements. A mere license, for example, revocable at any time, can be transformed following a conveyance into irrevocable and binding legal easement for the disponee of the nascent dominant land and the successors in the title. As such, the section can take effect at times, and in circumstances where the parties would not have mutually intended its operation. Therefore, it is submitted that even a statutory effort to provide for intention can, at least in some instances, fail to achieve that objective. In conclusion, we have seen how the law of implied easements has suffered from uncertainties and lack of clarity. It has been said to be an area of the law that is unnecessarily complex, with overlapping tests that are not easily demarcated. Further, or alternatively, it has failed to provide effectively for establishing intention. The chief recommendation has been via statutory reform, but statute must be interpreted, and the Section 62 has been used to uplift certain rights. It is therefore submitted that while statute is advisable, those legislating must be careful not to add further uncertainty. And I would like to finish my presentation. Thank you very much.